And I'll let you know when we're ready.
Okay.
Okay, you can put us on, Shannon.
What?
Yeah.
Hello. Okay.
Good morning.
Good morning.
Airway versus Rogers. Council, state your appearances, please.
Joseph Spiegel for Rick Rogers, Ryan Rogers, and Brett Rogers.
Good morning, Your Honor. Bruce Inocencio on behalf of the plaintiffs. My sincere apologies for the oversight. This got on my calendar for 10 a.m. because that's when last week's hearing was scheduled. And when we moved it today, it appears that I did not realize that the hearing was set for 8:30. So I apologize that everyone's been waiting. And of course, my office is technically closed right now, so we don't have anyone manning the phones. And I'm sure someone's been trying to call. So I apologize for that.
Apology accepted.
Apology accepted.
Thank you.
Mr. Spiegel, this is your motion. Go ahead.
Very briefly, the statute, as set forth in my papers, gives the absolute right to these documents. So does the common law going back to 1861. This motion is not about a settlement, which I thought was to be confidential. My clients are entitled to the information regardless of any proposed term sheet. There is important information that is needed, and as set forth by the Court of Appeals, shareholder who has a genuine good faith interest in a corporation's welfare or her own as a shareholder is entitled to inspect those corporate books that bear on her concerns. I think it's pretty clear, which includes payroll records. I have submitted, and I won't go into any more detail, correspondence, and I have also looked at the bylaws of the corporation, which substantiates the ability to review books and records. And I have looked at the operating agreement, similarly giving the same rights. I have provided a declaration by an accountant. And finally, exhibit number 7 is a fairly good summary of my client's position, all of which we have been provided to the court. Does the court have any questions?
I guess the only question is why, if you've already agreed upon a value, methodology for determining allocation of the purchase price, do you need these things?
The purchase price has nothing to do with Schedule K-1s, with the profit sharing plan, with the distribution of profits and losses as of the end of 2020. And the other issue is whether or not those numbers are going to be correct. There was a distribution of $750,000, part of which was attributable to 2019, some which is attributable to 2020. My clients are going to receive Schedule K-1s. They do not anticipate and will not accept anything that violates the Internal Revenue Service code in the way of allocations, and they don't want what is commonly referred to as phantom income. The settlement agreement has nothing to do with this motion. There may not even be a settlement. There's no signed agreement. There is no.
God bless you.
There's no signed agreement. It is essentially a term sheet without any documentation in support. My client hasn't signed it. No one has signed this agreement. It is essentially a proposal. It is not an agreed upon total resolution of the claims of my clients who are still Rick Rogers is an officer, director, and shareholder and remains that to this date and may remain after December 18. Ryan Rogers and Brett Rogers are members, along with Rick Rogers, of Brit LLC, and the alleged term sheet has nothing to do with Brit LLC and the distribution of profits and losses. So there is so much that needs to be resolved before there is any formal settlement that this is why we're absolutely entitled to these documents. And in fact, the case law specifically says even after they have resolved their issues, they would still be entitled to this information. So the case law, the statute, we have an absolute right to this information. There's just no doubt about it. And there won't be a settlement unless we get it.
Mr. Inocencio?
Thank you, Your Honor. May I start by asking counsel a question? The last statement there was there's case law that supports that even after this is resolved, that there's entitlement to this information. I'm not aware of any case that would permit, and I'm happy to be corrected here, but I'm not aware of any case in the state of Michigan that would allow someone that's no longer a shareholder, officer, or director of a company to have the type of information that's being sought here.
If you give me a half a second.
Okay, and feel free to take a look at that and you can respond when I'm finished. But I just want to let you know that that's a little bit of a concern for me. I'm happy to be enlightened. Your Honor, the comment relative to Brit LLC not being part of this, it absolutely is part of this. This is a complete global resolution. We have an agreement. Counsel for the defendants has repeatedly in his pleadings or in his papers indicated that the parties do have an agreement. We aren't refuting that there is an agreement. We aren't refuting that they are entitled to documents. The question that we have is what more specifically have we not provided that we are legally required to provide? We've already provided a significant amount of information, and my clients are not only trying to run the business, but they're also trying to get all the financing in place and handle all the insurance and take care of all these details. So if I look at the statute that applies, what is controlling here, the first section talks about providing information for a fiscal year. That information has been in the possession of the accountant for this company, Mr. Grossbart, the preceding accountant, for a long time, and all that information was already provided to the defendants through their tax returns. They have that. So I don't think that that is an issue. Section 1 of the statute simply does not apply. Okay? If I'm wrong, again, we're happy to be corrected, but I believe all of the information that is being sought that would fall under subsection 1 of MCL 450.1487 has already been provided. Am I correct in that regard, counsel?
No, it is incorrect.
Okay, so you're saying that your clients do not have the year-end 2019 balance sheet or the statement of income for 2019. They don't have those.
Those are incomplete, and they are questioned. And the bank statements, the check register. Let me give you one example. Let me give you one example. For example, Airway pays the dividend. I'm sorry.
Hold on. Let Mr. Inocencio finish. It's his turn.
I'm taking this one at a time, Your Honor. And if I don't want to get through smoke and mirrors here, let's look at the controlling statute. MCL 450.1487 is what is being relied upon here. I believe that's the correct statute.
Is that section contained in either one of your filings so I can have the language in front of me?
It is in my brief in support of my motion, Your Honor. All
right, give me a second.
Sure.
All right. Oh, okay. All right, so,
Let's look at this
Or
first
first
subsection.
balance sheet as of the end of the preceding fiscal year, its statement of income for the fiscal year, which is the preceding fiscal year, and if prepared by the corporation, its statement of source and application of funds for the fiscal year. Mr. Spiegel, you're saying your clients don't have any of that?
They don't have the sources and application of funds for 2019 in its completeness, but we're relying on section 2.
Wait, hold on. Wait,
We're gonna do it one at a time.
Okay.
Your Honor, with respect to that, we don't have a statement of source and application of funds to provide. If the court will review the subsection, and this is why I want to take it one at a time. The specific reference says, if prepared by the corporation. We don't have that.
So
But the other two
corporation-
documents, the balance sheet and the statement of income, that was provided to them long ago. So I think we can move past subsection 1 if I'm incorrect. Then we can go to subsection 2.
All right, let's talk about subsection 2.
Okay. We do not dispute, obviously, what the law provides as far as the rights that are available to any shareholder of record. We also don't dispute that Rick Rogers, Mr. Spiegel's client, and Doug Rogers, my client, are the only two shareholders of Airway Welding, Inc. And let's assume for purposes of this argument that this also translates over to the members and their membership interests in Brit LLC. So there's no dispute that the parties are all still shareholders in those respective entities. Okay, so what is it that they have the right to review? Well, they have the right to review the stock ledger. They have that. They have the right to review a list of its shareholders. They have that. There's no doubt. They know who everyone is. It's just the 6 people, or you know, the three people on Rick's side, and the father on our side, Doug, and his children. And so there's no dispute as to who any of the shareholders are. So then it gets into, and it's other books and records. If they give us written demand describing with reasonable particularity his or her purpose and the records he or she desires to inspect, and the records sought are directly connected with the purpose. We have provided already a vast array of documents, as the court, I'm sure, is aware, in light of what I typically see with this court is its review of the pleadings before we get to the hearing. And the court can see everything that was already sent on to Mr. Spiegel or his clients. So at this point, it seems like we're bordering on harassment. There's no requirement to give these items every single month. The statute doesn't provide for a release of documents every time there is a new development with the company. We provided all this. It's up to date. This argument that there might be some type of a K1 effort here to do phantom income, Your Honor, this is a red herring. Steve Patch, who was the new accountant for the company, is going to have to issue K1 documents to both Rick Rogers and Doug Rogers when the 2020 tax year returns are prepared. Those documents are going to have to reflect the parties' percentages as they were based on the parties' agreement. When this thing closes out, we can't generate phantom income as a result of that. Mr. Patch isn't going to put his CPA license on the line in an effort to engage in fraud to somehow suggest that all of a sudden Mr. Spiegel's clients are now going to be receiving income that they did not receive. That's not going to happen. These are simple, these are numbers that are going to come from the parties' agreement and the allocation. And without going into the specific numbers, there's no doubt that the parties have agreed on a number that is the purchase price. There's no dispute about that. And this is why I did not include the exhibits in the file or the documents that were tendered to the clerk, but attached them to Mr. Spiegel's copies and to the court's the judge's copy. The number is the number. We get to determine which numbers are allocated to which entity. There's no dispute about that. And so the K1s will flow out of those numbers. What is going on right now in the background as far as profit and loss on a monthly basis, that has nothing to do with any of these figures. This is an effort just to harass, annoy, and churn the file. There's no reason to provide this information at all. There's not a proper purpose. And this is why I went through the sections in the statute carefully, because in section 2, there has to be a purpose, and it has to be directly connected with the purpose. The record sought. What's the purpose of these documents? That's the question at this point.
Well, the purpose needs to be contained in the written demand. Where's the written demand?
We have submitted, Your Honor, a number of written demands. It's exhibits 1, 2, 3, 4 of my initial filing. However, if you turn to exhibit 7 of my reply, which is attached to my reply brief, a November 6, 2020 letter.
Is that the, all right, hold on. Is this the supplemental materials and support?
Well, yes, you can look at that first, because attached to that is the affidavit or the declaration of the accountant, which gives a specific list of documents and the purpose for which they are to be provided. A very detailed list, much more detailed than in the Hammond case, Your Honor, much more
All right,
detailed.
hold on. All right, I've read the declaration. Where's the letter?
It is exhibit number 7. It is a letter dated November 6, 2020. It is in the reply brief that I filed on Wednesday.
Okay. All right, thank you.
And
You may
exhibit,
continue.
oh, I'm sorry, is it my turn or Mr. Innocencio?
I don't think Mr. Innocencio's done.
That's correct.
But if there, I did ask a question though about the written demand, and I now am familiar with what you're relying on as the written demand. Was there anything else in response to that?
Yes, you can see by Exhibit 1 of my initial motion, a letter of September 29, and then I followed up with similar letters to the accountant, and finally another letter on October 27, 2020, again, detailing exactly what has been requested in the purpose, and even suggesting that the accountants get together and just exchange the information, which is common in these types of situations. So,
Your Honor,
Mr. Innocencio, is the company's accountant in possession of all of this information?
my understanding is that the previous accountant that handled the taxes for Airway Welding and Britt prior to Mr. Patch just recently becoming involved in the past couple months does have some of this information. And I believe this was already provided, most of this information was already provided to Mr. Rogers, Rick, Mr. Spiegel's client. I don't typically use first names, but since we're all in the family here, to Rick Rogers, Mr. Spiegel's client. So if I look at the letter attached to Mr. Spiegel's, if I look at the list attached to Mr. Spiegel's letter, okay? So if we look, for example, at Exhibit 4, that's kind of what started all of this. This is Exhibit 4 to Rick's, the defendant's motion. And in there, you'll see page 3. This is a letter. Information not yet provided or needed as of October 27, 2020. So what we're doing here is we're asking for quarterly income statements. We're asking for check registers. There is no need to provide a shareholder of a company a check register. This matter has settled, and if you look at the first page of the letters, they say settlement agreement in Rogers versus Rogers. There's no dispute that this case has resolved itself, and we're simply waiting to close on December 18th. And now that we have a final determination from the SBA liaison telling me that it has to be in the form of a redemption agreement, we're proceeding in that fashion and getting all the insurances lined up and so on and so forth. But all of this other information isn't going to change any of the allocation. It's not going to change the amount that's agreed to be paid. And just so you know, I think that, frankly, I don't know if the court would be willing to do this, but I'd like to see one of the exhibits that was attached to Mr. Spiegel's filing of this week stricken, because it includes the purchase price, even though that was supposed to be confidential. Is the court opposed to removing that from the court file?
I wasn't aware that something with the settlement amount had actually been filed with the court.
Sure. I believe it's Exhibit 7. On the second page, it references the purchase price, which is accurate. I just don't want it included in the court file. We agreed to keep it confidential. And I'm sure it was an oversight. I'm sure it was not intentional, but I think it would be appropriate to remove it.
I have no objection to just
I
deleting that number. I don't care.
I can direct that be redacted in the official court file.
Okay.
We'll make sure. Let me write myself a note to make sure I do it.
Okay, I appreciate that, Leonard. But so that is the number, and that includes the acquisition of the interests in Britt that are owned by Rick and his sons, Brett and Ryan. That includes the acquisition of Rick's 50% interest in Airway Welding, Inc. It includes a transfer of properties that are jointly owned between Rick and Doug, the two brothers here. Rick's getting the property out on Van Horn Road. Doug's getting the property on McKay Street that's in the city of Jackson. And the allocations for those figures and those properties, those assets are going to flow out of a determination to be made by Mr. Patch. All of that information will then be set forth in the K1. There's not going to be any type of phantom income here. Rick Rogers, I keep doing that, Mr. Rogers, but Rick Rogers will receive an allocation related to 50% of his interest, or all of his interest, which is 50% of Airway Welding Inc. And he'll receive allocation related to 46% of Brit. And his sons will each get 1 1/3% of Brit. There's no dispute about who the shareholders are. There's no dispute about their interests. And to suggest that there's some type of a phantom income possibility, and this is why we're going through this dog and pony show, it's absurd. If we hadn't produced any records at all, Your Honor, I would have produced them before this hearing so this court could not take me to task. I know what the statute says. They have a right to certain documents, but look at what we've already produced. And here we are again, 30 days later, saying, well, we need all this information. You have it all. You have everything that you're entitled to legally. That's the issue here. What are we legally required to provide? Look at the statute. We have provided it. This is another effort to just keep churning this file. My clients don't have time to keep dealing with this stuff. They're trying to run the business and get this thing to a closing in a month.
So if the accountant or accountants have the information that Mr. Spiegel's clients are looking for, why not allow the accountants to get together, look at whatever it is that they want to look at, that doesn't put your client to any additional work. Obviously, they're probably going to get billed by their accountant, but defendants are going to get billed by their accountant.
Okay, so in response to that, I don't think that's an inappropriate approach, okay? But let's look at what I believe to be the most recent letter that's requesting the information. And I could be wrong here, but I believe it's the letter dated October 27th. Is that right, Mr. Spiegel?
The letter dated October 27th has been supplemented by the affidavit, or rather declaration, of Mr. Friedman.
This is stuff that Mr. Friedman is looking for to perform what he understands to be his task as the accountant for the defendants.
Correct.
None of that's going to matter, Your Honor.
Whether it's going to matter or not, I think the best way to expedite this is to authorize the accountants to communicate, share whatever it is that defendant's accountant believes he needs in order to properly advise his clients as to the economics of this deal, and let's just get that done. I mean, I've been looking at the language here in the Business Corporation Act Section 2. It's other books and records. I can't imagine anything more expansive than that description. And granted, it's very specific about the stock ledger and list of shareholders and about balance statement and statement of income, et cetera, for the prior fiscal year. But its other books and records is about as expansive as I can imagine. It includes all their books and records. So what I'm going to order is that the both parties authorize their accountants to communicate and share this information so that we can move this thing forward.
Your Honor.
That's fine by me, Your Honor.
Your Honor, I think that part of what has been requested in the list, unfortunately, insurance policies, deeds, I'm assuming that you're only talking about information that's in the presence, that is in the possession of the accountant because there's information that's been requested that has nothing to do with accounting that I don't want to be dealing with going to the accountant saying, well, this isn't the list. So I know the court's issuing an order and I don't want to belabor this, but I want to provide some specifics here so we're not back in court in a week. So
Well,
I'm assuming that does not include deeds.
Correct.
Well, I'm assuming the copies of deeds is referring to prospective deeds prepared in conjunction with the consummation of the settlement agreement.
I don't know.
Correct.
Is that true?
Well, those, they're going to have to be produced at some point, obviously.
absolutely.
Why
I don't know
when
if
they're
you-
done. It says a copy of a draft of the settlement agreement. Well, there isn't even one yet, but
Right.
obviously that's something there shouldn't be any hesitation to share.
There's not.
I get that they're going to want to see all of the documents that are going to be necessary to consummate the closing. Of course, they need to
Right.
see those things in advance.
Don't disagree with that at all. What we will connect the accountants, Your Honor.
Let's do that.
Sounds good.
Thank you.
Terrific.
Thank you.
Thank you, Your Honor.
Have a good
You're
day.
welcome. Have a good day, gentlemen.
Have a
You
good
too.
day.
Again, I apologize for the delay.
No problem.
No problem.
Happens to all of us.
Thank you.
Okay, well, I've got somebody in the waiting room. Let me see. Who that is. Is Knutson versus Gassert still on the docket?
It's scheduled for 8:30.
Yeah, but nobody's appeared. I'm guessing they must have worked it out.
Yeah, I haven't heard anything.
I mean, it was pretty straightforward. Leave to file an amended answer. And whoever was in there just logged off, so